Okay, good evening, everyone. It is now 7 o'clock, so we will start. So yesterday we did two questions, right? We did two questions. We did one slowly. We took our time, and the second one is a bit faster. So today, that's the plan. We're just going to look at more questions, right? I've got 3 hours with you. I've been informed by the helper that they want to do a student survey. No, it's not a survey, student satisfaction thing. So when I give the break, don't leave immediately. I will call her in, and then you do the survey thing, and then after that you will get 10 minutes. So apparently she said it takes 5 to 10 minutes. So you do that, you give it back to her, then after that you get 10 minutes of a break. Okay? She first suggested some other plan, but like she will give it to you now and you will write it during class. I didn't think that was great, right? So that's the plan. Okay. Okay. So let's come back to the question. So today we will look at this question, we'll look at another question, and then once we're done with those, I have two more questions without an answer. I will just pop that up on the screen, and then we'll try and do those as well, right? The more questions we do, the better we get at it. Just take a few minutes to read this one. Then after that, I'll read it with you also. So as you're reading, immediately, what are the rights? Who is claiming for them? From whom? Right? Those are the things you want to pick up immediately. Okay, if you've read it once, let's just try and read it again and see whether we can pick out the issues. Andy was the registered owner and occupier of a house with an adjoining commercial garage. So something like this. Do you all use the word garage here in Hong Kong? If you're speaking English, what do you call a mechanic, car mechanic? Do you call it a car mechanic? Yeah. So this is another one of those cultural differences. So in the UK, if you say garage, it is understood that it's a place where you send your car to be repaired. But in Malaysia, if we are speaking in English, it's just a place to park your car. You see? And if that was the understanding you took, it's a significant difference in how you would understand the question that could possibly impact the answer as well. However, in this particular question, there are a lot of context clues to tell you that actually it is a car mechanic shop. So even if the word garage alone won't throw you off entirely, if you have read the entire question, you will realize that it is a place where you send your cars to be repaired. But again, this is a little bit of a danger, right? The words that are used sometimes may not be used the same way as they are used in the UK. I don't think it is a major issue, but this is something to remember, right? Something to think about. So Andy was the registered owner and occupier of a house. So this is the house, let's say, right? So house, and then this is the garage. And Andy owned both, right? In 2007, when Andy retired, he granted Barney a lease of the garage. He granted Barney a lease of the garage for 5 years. For many years, there had been an advertising sign advertising the garage on the side wall of the house. So let's say here, this is the advertisement sign on the side wall. This is the main road, let's say, for example, right? This is the main road. So for many years, there had been a sign advertising the garage on the side wall of the house next to the main road. However, Andy removed it a few weeks after Barney took possession of the premises. The forecourt of the garage, so let's say forecourt. The forecourt of the garage is quite small, and Andy had occasionally parked cars awaiting repair on the drive of his house. Andy, so this is his house. So this is the drive, right? So Andy had occasionally parked cars awaiting repair on the drive of his house. But when Barney began doing so, Andy asked him to stop. In retaliation, Barney told Andy that he would no longer be allowed to cross the garage forecourt, which separated the drive from the main road. Oh. Okay, let's say the main road goes like this. Again, these pictures, you just make it up as you go along, as long as it kind of fits. So I think the forecourt, the drive seems to be something like this, very strangely built house. The drive goes through the forecourt and then it connects to the main road, right? If I understand correctly. If your understanding is different, let me know. Let's read that again. The forecourt of the garage was quite small. So forecourt, I assume, is the space in front of the garage, right? And Andy had occasionally parked cars awaiting repair on the drive of his house. So this is the drive, right? This is the drive. So sometimes when Andy was running the business, when there were too many cars to be repaired and he couldn't fit in the forecourt, what Andy used to do is he will park it in the drive. Okay? But then when Barney began doing so, Andy told him to stop. Okay, fine. In retaliation, then Barney told Andy that he would no longer be allowed to cross the garage forecourt. So you see, for him to drive his car to his house, apparently he has to cross the forecourt. So now Barney is saying no. So what does that mean? This prevented Andy parking his car on the drive, although it was still possible to access the drive on foot via a footpath that ran between the forecourt and the house. So apparently there was some kind of footpath here, very narrow footpath. So if he wanted to, he could walk through the footpath to get to the drive, but he couldn't drive his car because the only way to drive his car was apparently through the forecourt, and then you get onto the drive. Are we good? A few weeks later, Andy and Barney decided they were both being petty. So then Andy allowed Barney to reinstate the advertising on the side of his house and said he could use the drive occasionally in return for Andy being allowed to resume driving over the forecourt. Right? In 2012, the lease was renewed for another 5 years. So there was an original lease in 2007, and then 2012 again, another lease. Remember, I told you what to look out for, isn't it? When there's a lease, and then a license, and then a lease, you know, that's immediately a 62 discussion. You see, you will start seeing patterns like this, right? You'll start seeing patterns like this, okay? So the lease was renewed for another 5 years, at which point Barney told Andy he was once again not permitted to drive over the forecourt. Andy consequently painted over the advertising sign and refused to let Barney use his drive. Okay, once again, before we look at the answer, can we just very quickly, how many rights are we talking about? I'm not even calling it easements yet because I don't know. How many rights are being claimed? 3? Yeah? Okay. So what are they? So firstly, it's the right to park the cars on the drive. That's one. And then the right to kind of drive your car over the garage forecourt. That's another one. So this is 1. This is 2. Then what's the third one? The advertising signage. This is 3. Now, of course, this 1, 2, 3 is just random numbering. I may not even follow that order. It's just for today, right? 1, 2, 3. Okay, fine. So who is claiming for what? So the right to drive across the forecourt. Andy is claiming for that, right? Okay. And then the other 2, Barney is claiming for. Barney is claiming for the advertisement signage, and Barney is claiming for the right to park his car, his customers' cars on the drive. Okay? Now, again, very quickly, you'll see very similar to the 2 questions that we did yesterday. Can we quickly point out likely how we are going to imply the easements? Let's start with number 1, the drive. Not the drive, the right to park the cars on the drive. What do you think? Who's claiming for that? Barney. What do you think? What are you thinking? Did Andy use it when Andy owned both pieces of land? He did, right? Right? He did. But there's a slight problem here, and it's a very slight problem. It's a very slight thing, but it's a big problem potentially. You look at this. Andy had occasionally parked cars. Why is this going to be a problem? It seems to be hinting at Wheeldon and Burrows, right? Quasi-easement. So when Andy owned both pieces of land, Andy was parking his car on the drive. So that is a quasi-easement in that sense, right? So when you see that, immediately you are thinking Wheeldon against Burrows, which is good. But for Wheeldon and Burrows to apply, if you remember, it must have been used by the vendor, the seller. So yeah, Andy used it, but it must have been used continuous. It must have been continuous and apparent. So I think the examiner is throwing in a little trick here because he uses the word occasionally. So normal English meaning of the word occasionally. When you say occasionally, it's actually the opposite of regularly, isn't it? Right? It means once in a while. It means not on a regular basis. That's why you say occasionally. That means on occasion, only when you need to, that kind of a thing. So that might be an issue there. That might be a problem because the continuous and apparent and necessary for the reasonable enjoyment of the land are both requirements for Wheeldon and Burrows to apply. So that's going to be an issue, right? So we'll talk about that. So if it is not Wheeldon, can we do 62? Potentially, isn't it? Let's say it's not Wheeldon. Can it be 62 or not? Think about it. So first there was a lease. Then after the lease, after the first lease, suddenly Andy and Barney decided that they were now friends again. And then what did Andy tell Barney? You can, where? See, Andy decided they were being petty. Andy allowed Barney to reinstate the advertising sign and said he could use the drive occasionally. So which means this seems to be a license. So if you have a lease, and then you have a license, then you have another lease, immediately in your mind, what are you thinking? Possibly 62. So ladies and gentlemen, what is the lesson in this? Don't typecast immediately like, oh, this is Wheeldon and Burrows. That means it cannot be 62. And you look at it differently, the same right could potentially be Wheeldon, it could potentially be 62 as well. And sometimes, ladies and gentlemen, you can answer that way as well. You can say that this could be Wheeldon and Burrows, but alternatively, it could be 62. Now, like in this question, we're looking at it totally differently. That's why it can be 62. But in another question, let's say, for example, if you remember when we did the lecture, I spoke to you about the case of Platt against Crouch, right? Now, we'll talk about it again later. But the case of Platt against Crouch is the case that says that for section 62, although the general rule for 62 is that there must be diversity of, or prior diversity of occupation, right? Long against Gowlett, Sovmods against the Secretary of State for the Environment. These two cases say that for 62 to apply, one of the preconditions is that there must be prior diversity of occupation. But Platt against Crouch comes and says no need. That, ladies and gentlemen, means that in some circumstances, when that right, you have identified it as a Wheeldon situation and it's successful, you can also go on to say, alternatively, this could also have been obtained by way of 62, read together with Platt against Crouch. Now, that's not the case in this question. But what I'm telling you is that is a possibility, right? So as much as, I told you yesterday, there'll be one reservation, 162, one Wheeldon. Don't close your mind too much to that, right? So sometimes the same Wheeldon might also be Wheeldon or 62. It might, right? So that's going to be a problem. That's going to be potentially the argument here, right? For number one. Number two, what do you think? What's number two again? The right to drive his car across the forecourt. Who's asking? Andy. Andy's asking for a right on land that he has just sold off or leased off, isn't it? So what is that? That's going to be reservation, right? See, not too bad, isn't it? The third one, the advertisement. The advertisement is likely to be Wheeldon against Burrows. Full-on Wheeldon against Burrows. Why? Once again, when Andy was running the garage and Andy was staying in the house, that advertisement was there, isn't it? Advertising the garage. So it was, the dominant tenement was the garage, the servient tenement was the house, and then the dominant tenement was leased to Barney. And prior to the lease, it was a quasi-easement. And so now the quasi-easement will become an easement in favor of Barney. Right? Yeah. Okay. So again, the more questions we do, this will become easier. It will, right? So this is why I like to do this exercise first. Without looking at the answer, let's try and identify. It's an important skill to develop, right? Any re-Ellenborough issues? You think so? No, not the law, but any issues you think will come up. Once again, as usual, I think there will be a degree of use issue for the drive. If Barney parks his customer's car there to the point where Andy no longer has reasonable use of his drive, that's fine. This degree of use is going to be only an issue. There are certain easements where it won't be an issue. The right of way, a right of way, it can never be an issue, isn't it? Right? If it's a pathway that you are walking on, even if you walk on the pathway 1,000 times a day, the owner still can walk behind you, isn't it? So for certain rights, this degree of use is never going to be an issue. Usually it'll be an issue for storage, for parking, where it is an enclosed space, that kind of a thing. Or here it's not an enclosed space, but when you put enough cars there, the actual owner, Andy, cannot use his drive anymore. That's going to be a problem, right? Other than that, maybe the advertising signage. Why do you advertise? You advertise because you want more business, isn't it? So what is the benefit of the advertising? Is it a monetary benefit? If it's a monetary benefit, then what do we talk about? London and Blenheim Estates against Ladbroke. In fact, you can argue even this parking the car here also might be a monetary benefit, right? Because he's not parking his personal cars, he's parking his customers' cars. Okay, ladies and gentlemen, see, if you got that, as we were reading the question and all of those issues, you got it and you understood it and all of that, then done. You should have no problems doing easements, right? So then, of course, apart from that, there's the tedious bit of actually writing it out. So you got the first one, re-Ellenborough Park, dominant tenement, servient tenement. But with enough practice, that will come, right? You shouldn't have a problem. Let's look at an answer that I have. This is my proposed answer. As usual, it need not be the only answer. All right. So yeah, I always like to do this introductory paragraph that just straight away talks about what are the easements that are being claimed for, or what are the rights that are being claimed for, who is claiming for it. And then, so are the alleged easements capable of being easements? There must be a dominant tenement and there must be a servient tenement, right? Do we have that on the facts? Right? Again, guys, as much as, although my notes make it very point form, very almost mathematical, when you are writing an essay, you need, it's conversational. Try not to make your essay very transactional. Like, okay, this is the first requirement, this is the second requirement, right? So you can talk to the examiner. So when these two requirements, the first and the second one, are so simple and so easy, you can combine them in one paragraph and write it out also. You see what I mean, right? Those things make a difference a little bit, right? When the examiner reads it, because it's always impression marking, right? He must not have the impression that you are just copying off some template that has been given to you. Right? The moment he gets that impression, and I've spoken to examiners, and we always talk about it, because property law is the worst performing subject always, every year. Did you all know this? Well, if you didn't know, I'm telling you now. When I say worst performing, I mean across the board. all 12 subjects that you are taking for your, if you're doing the regular route, or 9 subjects that you're doing if you're doing the graduate entry route. Property law is regularly the worst performing subject. You know what? Second is equity and trust. These are the 2 worst performing subjects across the board, not just Hong Kong, Malaysia, Singapore. It's across the board everywhere, right? So maybe what I'm trying to say is give the subject the due respect that it deserves. Don't treat it the same way as your other subjects. If you got away with it last year, 1 week before the exam, 1 month before the exam, this subject don't do the same. That's my advice, right? This subject don't do the same. And this is not just, oh, I'm teaching it, so it's the toughest subject, I'm thumping my chest. No, this is statistically data-driven points that I'm giving you. It is consistently every year the highest failure rate subject across the board, right? Okay, so coming back. There must be a dominant tenement and there must be a servient tenement. So on the facts we have for both, right? So for different rights, there are different, the different lands become the dominant or the servient tenement. So for the right to walk across the garage forecourt claimed by Andy, the dominant tenement would be the house and the servient tenement would be the garage. For the rights claimed by Barney, of course, the dominant tenement would be the garage and the servient tenement would be the house. Okay. Why do I know that is because the servient tenement is always the land on which the right is exercised, right? Then the other is the dominant, or the land that benefits is the dominant land. There must be diversity of ownership or occupation. That's satisfied as well. Even though Andy owns both pieces of land, right? Even though Andy owns both pieces of land, but the fact that it is occupied by different people is enough. Okay. Next, the alleged easement must accommodate the dominant tenement. Okay, so the proximity issue, not a big deal. It's close to each other, right? Okay, so let's pick up on issues. Firstly, the advertising signage. We spoke about this, right? The advertising sign. Potentially, this could be purely an economic benefit to Barney, right? Purely an economic benefit to Barney. If that is the argument, it's purely an economic benefit, then, ladies and gentlemen, the case of Hill against Tupper, remember, Hill and Tupper was the pleasure cruise case, right? Hill against Tupper says cannot. But Moody and Steggles, ladies and gentlemen, and tell the examiner the facts of Moody are very similar to our facts today. What are the facts of Moody? It was the pub, right? It was an advertising signage advertising a pub. And there, although the courts, there was an argument to say that it's an economic benefit only, but in Moody itself, the courts held that because the entire nature of the land was the pub, the land was nothing else but the pub. So when it benefits the pub, it benefits the land. That was held in Moody. So honestly, the same argument can be done here also, I think. We can follow Moody against Steggles directly because the entire nature of this land is the garage, isn't it? There's no other land other than the garage. Every piece, every square inch of the land is the garage. So the advertising sign, if it is advertising the garage, you can argue it's advertising the land. It's benefiting the land. But I didn't go that way. Of course, Moody and Steggles was at a time when there was no London and Blenheim estates, right? So since today we have the London and Blenheim case, I'm going to argue that. Does everybody understand what I'm talking about, right? So the issue here is the advertising signage potentially is not benefiting the land, but benefiting the landowner only because it is purely an economic benefit. But to sort that out, the case of London and Blenheim estates against Ladbroke confirms this, and a distillation of the cases suggests that today, if there is a purely economic loss, purely economic gain, pure economic loss is taught, isn't it, right? If there's an economic gain, it does not matter. It does not immediately negate the easement. So if there is a commercial benefit, it's okay. The issue is, how does the commercial benefit accrue to the dominant tenement owner? It must be accruing to the dominant tenement owner because he owns the estate in the land, because he is on the land, right? Barney would benefit from the advertising sign only because he is leasing the garage, isn't it? Can you imagine if he was not leasing the garage? If he was somewhere else, will the advertisement in this particular place next to the house, is it going to benefit him? Not really. It only benefits him because, and somehow it's an advertisement of the garage, not just a general advertisement. The advertisement of the garage will only benefit him if he is leasing the garage. So any commercial benefit that he is getting from the advertisement is accruing to him, is coming to him because he owns the rights in the land. So then that's okay. The London and Blenheim test is satisfied. Right? So, conclusion. Even if you did argue that the advertising signage is an economic benefit, the London and Blenheim test can solve that problem. Some of you may not. Some of you may have just gone to apply Moody and Steggles directly because the facts of Moody is directly on point here. It's an advertising sign for a business. You could have also, right? Now, what about the other rights? The right to park, I am arguing that the other rights benefit the land directly, right? The right to park will benefit the garage as it provides more space, and the right to drive across the forecourt. I mean, that's also a benefit, isn't it, right? The owner of the house now will have the ability to drive his car all the way to the house. If not, means the owner of the house will have to park his car far away, right? So you can argue that it directly benefits. But if some of you disagree with me and you think that, no, the right to park the cars on the drive is also an economic benefit, then what you do is you discuss it together with the advertising signage. You could have done so. Not a big deal. Do you understand what I mean? So this is a decision you need to make in the exam. Are there any rights here that could potentially be an economic benefit? And that's how you deal with it. If not, then just argue how it benefits the land directly. But you must have that argument. That's the point I want to make. Right? Don't do the whole on the facts, this is obvious. You know, that kind of a answer. Again, I've heard it straight from the examiners. They hate that. Right? Tell why. Don't say anything is obvious. Just tell why. Right? As obvious as it may seem to you. Okay, moving on. The alleged easement must be capable of forming the subject matter of the grant. So this one again, how do we start off? Capable grantor, capable grantee, right? Do we have that? Yes, we do. And then is the right certain? I think they are sufficiently certain, isn't it? Once again, take a look at it. It's the right to park your car on the drive. Very clearly stated. The right to drive your car on the forecourt. What's the third one? The advertising signage. Specifically, it's not just a random, I can hang up an advertisement anywhere on the land. It's specific on the wall that is facing the main road. See, all of that is being put down for good reason, to tell you that these easements are specific, is clear. And then, are these easements capable of being easements? Now, you can go about arguing it, or you can save the time and bring up a case. I told you this yesterday, right? Bring up a case to show that this particular type of easement has been recognized as an easement before. So on our facts, we've got 3. Advertising signage, Moody against Steggles. Parking, Newman against Jones. Right of way across the land, Borman against Griffith. Remember I told you, have one case for the usual rights that you will find in the exam. And I gave you about 5 usual rights, right? Just keep a case for all of that. Once again, I remind you, you are not saying that just because in Newman against Jones it was allowed, that means here it will be allowed also. That's not what you're saying. You are just saying that the right to park has been recognized as a right that is capable of being an easement before. So I don't have to argue that again. Okay? So all the rights are capable of being easements. Very good. Do we have any potential issues? Just like we highlighted earlier, the right to park. This will be a degree of use issue. Every single question so far, you will notice we've had degree of use issues. We've had, does it benefit the dominant tenement issues, right? So you can see that there are very common issues. Try to work on those, right? Now, again, not every question is the same. So I'm going to try and show you some more varied type of questions, but effectively they're going to come. I haven't seen a question. I haven't shown you a question yet on the right to recreation, right? But yeah, so we will look at some of that, but it's very usual, the issue. So you can work out sort of an answer now itself. This is what I always tell students. So you know there's going to be a Section 62 discussion. You know there's going to be a Wheeldon discussion. So work out now, if it's going to be a 62 discussion, what is going to be your opening line? What are the words you're going to use to explain what is Section 62? What is the rule in Wheeldon and Burroughs? All that, do now. Do now, keep it somewhere. Because you know you're going to use it in the exam. Make it your own, make it unique, so that, you know, pick it up from some textbooks or whatever. Don't take it wholesale, right? Then there'll be plagiarism issues. But sort all of that out now, right? It's still an open book exam, so take advantage of it. I have it on good authority that the university will not continue keeping it as an open book exam for very long, right? They feel that the integrity of the exams are going down. The past few years, they've had to. This year already, there was already apparently a big debate at the university. So the way it's going, I suspect even next year it may not be open book anymore. But I don't know. I genuinely don't know. This is me speculating, right? I don't know. But I do know for a fact that this year itself, there was a huge debate already. The reason is because, like I said, the University of London exams have been highly regarded because they're tough. But apparently the fact that it was open book for the past few years has diluted that a little bit. The people at the university don't like that. The people at the university obviously are very old-fashioned, right? So they don't like that. So it's going to go back to closed book. But what will never go back is they're never going to go back to pen and paper exams. That one, the university has 100% guaranteed us. They will never go back to pen and paper exams. So it's going to be like what it is this year. It'll be in a hall, it'll be invigilated, but it will be with the Inspera system on your computers. Right? Okay, moving on. The right to park, right? So degree of use, right? If the amount of parking results in Andy no longer having reasonable use of his own drive, this cannot be easement. This cannot be an easement. Give an example. So Bachelor against Marlowe, the right to park several cars. It was just two or three cars on the alleged Servian land. The courts held that it couldn't be an easement because the impact on the land was so great. But in the case of Nissan Motors, ladies and gentlemen, R Square Properties against Nissan Motors, 80 cars were parked and it didn't matter. So that two cases tells you that it's not really about the amount of cars that are parked, it's about the impact on the land. If your land is so big that even parking 80 cars is fine because you have a lot more land that you can use, that's okay. That's going to be a easement. But if your land is so small that even parking 2 cars or 1 car already restricts you from having reasonable use of your land, then it cannot be an easement. So it's a case-by-case thing to be discussed. Every circumstances differently, okay? So we are told that Andy used to park the cars there, awaiting repairs in the drive occasionally. It is submitted that Barney also will probably want to do the same. Assuming that the drive was large enough to accommodate more cars, and Andy could also park his cars there, the court will allow the easement. So once again, this is your typical problem. You don't know how many cars Barney wants to park. They didn't give you measurements of the drive, nothing. So you have to assume. So we will proceed on the basis that it will be allowed as an easement, right? It will be allowed as an easement. Are we okay? Do you think we have missed anything? Right? Did you spot something that I didn't discuss? And whenever I ask that question, I genuinely ask that question. I'm not, right? So did you, when you read the question, did you spot something that I didn't? Right? If you think of something later, let me know, right? Okay, so then we move on to the acquisition. I told you, Re-Ellenborough discussed together everything. The acquisition bid, it has to be right by right. It has to be, right? So advertising signage first. What did we say about advertising signage? Right? I think it's potentially Wealden. Let's see whether it work out or not. Assuming there was no express grant, obviously, well, we were not told of an express grant, isn't it? So Barney must look to imply the easement in his favor. Barney will argue an implied grant, right? Why? Because for Andy, it's an implied reservation, but for Barney, it has to be an implied grant, right? So there are 4 ways to imply a grant of the easement. This paragraph, ladies and gentlemen, in your actual exam, this paragraph will not be necessary. Right? Remember, I draft out these answers with teaching in mind. So this paragraph is just telling, it's almost like lecturing, this paragraph. There are 4 ways to do it. The first way won't apply. The second way won't apply. If it doesn't apply, why are you even saying it? You understand what I mean, right? So remember those things. Go straight to the issues. Go straight to the issues, right? So I think it's definitely not necessity, right? Nowhere is an advertisement a necessity. Without the advertisement, you cannot use the land. No, right? There was no common intention also as far as I can see. So, can it be Wealden against Burrows? Let's try. Barney is advised to argue the application of the rule in Wealden against Burrows, right? So, what does the rule say? When a person transfers part of his land to another, so it must be the dominant part of the land pertaining to that right. The dominant land must have been transferred. So I use the word transfer because it could be sale, it could be lease, right? That transfer impliedly includes the grant of all quasi-easements that the seller used and enjoyed prior to the transfer for the benefit of the part transferred. It's just a very roundabout way of saying when the seller sells the land. So here, when A sold the dominant land, which is the garage, when A leased the dominant land to B, all quasi-easements that he used, A, will become full easements in favor of B. That's the rule, right? All quasi-easements that A used will become full easements in favor of B. That, ladies and gentlemen, is the rule in Wealden against Burrows. So this is what I was telling you. You know you're going to have one paragraph to explain the rule in Wealden against Burrows. You know. Prepare that now. You understand what I mean? Write it down somewhere. You can take it into the exam. Right? You want to use mine, can, but there are many, many students that will have this. That's the point I'm making. Right? So then it'll become very similar to everyone's answers. Okay? So we are told that the advertisement signage was there prior to the grant of the lease of the garage to Bani. That means when Andy was operating the garage, he was using the signage as well, isn't it? So this is your classic quasi-easement. Andy was the owner of the house. Andy was the owner of the garage, and he put up the advertisement in the house that was advertising the garage. But there was no diversity of ownership or occupation. So that is a quasi-easement. Then upon signing of the lease, the right to use the signage would be transferred to Bani as well. Right? But for Wheeldon and Burrows to apply, there are some preconditions, correct? Provisos, they call them, provided. First one, it must be continuous and apparent and necessary for the reasonable enjoyment of the land. The case of Wood against Waddington clearly tells us that both need to be satisfied. Both need to be satisfied. So is it continuous? Well, on the facts, it had been used continuously by Andy all the way to 2007. Right? And as all advertisements go, it would be apparent. Right? It would be a really lousy advertisement if it wasn't apparent, isn't it? Right? So I think it's apparent, and it was continuous. It just has to be continuous all the way to the point of the lease, Because some of you may be concerned about the fact that right after the lease, right after Andy leased the garage to Bani, Andy stopped Bani from using the advertisement, isn't it? Right? You see, For many years, there had been a sign advertising the garage on the side wall of the house next to the main road. However, Andy removed it a few weeks after Bani took possession. So some of you may be concerned about this. Andy removed it. Does that affect the continuous? Answer is no, because the requirement of continuous and apparent is up until the transfer, up until the lease. He removed the advertisement after the lease. That doesn't matter. Well, it doesn't matter for the application of Wheeldon and Burrows. No. It matters that actually by right, he shouldn't be doing that. Because if Wheeldon and Burrows applies, Bani already has the lease. Andy cannot simply take it down. But for the application of Wheeldon and Burrows, that does not matter. Okay, so coming back here. So upon signing the lease, the right to use the signage would be transferred. Okay? Continuous and apparent. It had been used continuously by Andy all the way to the 2007 lease. Now, again, this is a common stumbling block. There are two leases on the facts. 2007 and then another one in 2012. Why do I know that it's the 2007 lease that is the triggering lease here? How can you be so sure? It's a very simple answer. It's a very logical answer, but I want you to think about it so that you're used to that line of thinking. So there's a 2007 lease and then there's a 2012 lease, I think. Why are we talking about the 2007 lease for the purposes of Wheeldon and Burrows and not the 2012 lease? I want you to establish the thought process, because then in the exam later, it may not be the first lease. Right? Okay, so the thought process should be this. Remember, for Wheeldon and Burrows, prior to the transfer, prior to the sale or prior to the lease, there must not be diversity of ownership or occupation, correct? There must not be. Because that's the only way you can have a quasi-easement, when there's no diversity. So the only lease that would satisfy that requirement is the 2007 lease, because at the 2012 lease there's already diversity of ownership, occupation, right? Right, so you need to think about that, huh? Okay, so then if the courts accept all these arguments, the rule in Wheeldon against Burrows will apply, and Barney would have acquired the easement by way of implied grant under the rule in Wheeldon against Burrows, right? But if the courts don't accept, right? If the courts don't accept it, the weak point here is it necessary for the reasonable enjoyment of the land? I think it is. Huh? See, the land is a garage. For you to use the garage nicely, I mean, it would be nice to have an advertisement for your business, isn't it? It would be good to have people to know, some marketing for your business. So I think definitely it will satisfy the requirement of necessary for the reasonable enjoyment of the land. But, however, what if the courts don't accept it? We are just discussing alternative possibilities. If the courts don't accept it, then you could try 62. Now, traditionally, guys, 62 and Wheeldon apply in totally mutually separate situations. Now, if you draw a Venn diagram of where 62 applies and where Wheeldon applies, the two circles don't overlap at all. Traditionally. Platt against Crouch has messed this up. I mean, I say messed this up, but Platt against Crouch has changed this, right? Platt against Crouch today says 62 can apply even in circumstances. 62 can apply even in circumstances where there is no prior diversity, like here. So we try. Today, as a result of the case of Platt against Crouch and confirmed in Wood against Waddington, the requirement for prior diversity is no longer necessary, but don't misunderstand. Huh? It is not a completely no longer necessary. It is no longer necessary if the right is continuous and apparent. Platt against Crouch applies. Prior diversity is not needed for 62 only if the right is continuous and apparent. If the right is not continuous and apparent, Platt against Crouch cannot apply. Again, for 62, traditionally, continuous and apparent is not a requirement. But if you want Platt to apply, continuous and apparent is needed. Okay? So the requirement for 62 to operate without prior diversity of occupation is that the right must be continuous and apparent, right? So on the facts, we've already argued earlier, it is continuous and it is apparent. So you will say that even if Wheeldon cannot apply, 62 will apply, right? Now, my suggestion to you is, in this kind of a situation, you still will try for Wheeldon first. Then only alternatively you try for. Now that you're looking at this, guys, think about this. I'm going to ask you a question. This was an essay question many, many years ago. It's no longer being asked today. Does Platt against Crouch render Wheeldon against Burrows redundant? Does Platt against Crouch render Wheeldon against redundant, useless, unnecessary? So, you know that whole Venn diagram thing I was telling you earlier? Traditionally, right, there was no overlap between when 62 will apply. This is 62. This is Wheeldon against Burrows. But today, after Platt against Crouch, ladies and gentlemen, right, The thing is, I think it's become like this. This is my opinion on the matter. So this is 62. This is Wealden against Burrows. 62 has significantly eaten into Wealden, the situations where Wealden and Burrows can apply. It has. But does it render Wealden against Burrows redundant? My answer is no. Can you think of why? Very quickly, remember what is the 62 doesn't change Platt against Crouch doesn't change 62 totally, The preconditions for 62 are still there. What are the preconditions for 62? There are two preconditions. The first one is it must be a conveyance. And the second one is the prior diversity. Platt against Crouch maybe removes the second requirement, but it must be a conveyance. That is still there. Wealden against Burrows can apply whether the sale is done properly or the sale is done in not following the proper formalities. So there is still where only Wealden against Burrows will apply and 62 cannot apply. So the answer to the question, has Crouch rendered Wealden against Burrows redundant, is no, it hasn't. But you will have to admit that Platt against Crouch has made Wealden against Burrows less important, because there will be a lot of times when 62 now will apply when last time only Wealden could apply. Are we good? Okay, very good. Let's move on. Let me just rub this off first. The right to park. Barney will argue implied grant here as well. And again, it's not going to be necessity. It's not going to be intended easements, right? It doesn't seem like it. The rule in Wealden and Burrows, well, how many of you would have tried to argue common intention? I think maybe, although my answer here, I'm saying it doesn't apply. But what I'm saying is I can see how you could have put up an argument. You see, when Andy leased out the garage to Barney, he knew that Barney was going to use it as a garage, isn't it? It's not like it's a surprise to him. He knew that Barney was going to use the land as a garage. And Andy, of all people, knows that if you are using that as a garage, sometimes you will need to park your customer's car in the driveway, because Andy was running the garage before, right? So, ladies and gentlemen, if you had wanted to do a common intention argument, I think you could have, right? But just because your necessity or your common intention is successful, don't just immediately celebrate and forget about it. If there could be alternative discussions, you must discuss the alternative discussions as well, right? Get into that habit. Remember, we are not looking for the end result, whether your client won or not. It's the discussion. So even if, it could have been common intention, but it also could have been 62, you have to discuss both. Okay? So I have argued, no, it's not common intention. That I'm sticking with that, but I'm saying that I can see how you perhaps could have had a short discussion on common intention, possibly, right? The rule in Wealden against Burrows will not succeed here, right? Why? Because at first glance, Wealden also could have applied. At first glance, Wealden could have applied. Why? Because when Andy was the owner of the house and he was the owner of the garage, he was still parking his cars on the drive, the customer's cars on the drive. But the reason why I'm saying Wealden doesn't apply is this. And we are told clearly that Andy used that right occasionally. Right? There must have been a reason why the examiner used the word occasionally. So for me, when you say it was used occasionally, it means it's not continuous. It's not continuous and apparent. Okay? So that is why I'm immediately saying no, Wielden. Right? And then 62. Also, honestly, the other reason for me, but this is an unfair thing, right? But the other reason for me is, from my many, many years of experience, I know if the examiner has already tested you on Wielden in the earlier part, it is highly unlikely that he's expecting you to do a full-on discussion on Wielden again. Right? So sometimes, guys, when you find yourself doing that, some of you might be thinking, oh, my prayers have worked. The examiner has given me two exact same issues in the same question. You need to stop and check again. Huh? Right? You need to stop and check again. If you find yourself that your answer is literally the same answer, Wielden against Burrows, explain the what is Wielden against Burrows, and then quasi-Eastman, all just changing the name only, check again. Something must be wrong. Right? Anyway, so I'm saying Wielden doesn't apply, so we're going to go for 62. For the same reason, though, the application of 62 will also fail. This is because there is no prior diversity prior to the 2007 lease. Okay, fine. However, we are told that after the 2007 lease, Andy allowed Barney to use the drive to park the cars awaiting repair. After the 2007 lease, he allowed Barney. At that point, this would be a license. The word allowed was used, right? License. Then when you see it's a license, the case of Hare versus Gilman and Inskip said that 62 works in a way that will transform a license into a easement, right? If 62 applies, it will transform what was merely a license into a full easement, right? Now, what are the preconditions for 62 to apply? Number one, there must be a conveyance. That transaction must have been done using the proper formalities. Secondly, there must be prior diversity. So here, prior to which lease? The 2012 lease, isn't it? Again, I want you to honestly ask yourself, do you know why it's the 2012 lease here and not 2007? Again, I mean, it's not a major issue, but it's the small things that can trip you up sometimes. Obviously, it has to be the 2012 lease, right? You cannot use 62. You cannot use the 2007 lease as to apply 62 here, because prior to 2007, there was no diversity of occupation. It cannot, right? And Platt against Crouch cannot apply in this situation because it's not continuous and apparent. It has to be the 2012. Further, the license that you want to be converted only started, the license was granted after the 2007 lease. So that is why it cannot be the 2007 lease. It has to be the 2012 lease. That is the triggering transaction, right? So 2012, if it was done by conveyance and there was prior diversity, 62 will apply, and the license that was given to Barney to park his customer's car in the drive will become a full easement in favor of Barney. Last one. The right to drive across the garage forecourt. Okay, so this is, Andy is asking for this. We already said Andy will be asking, will be arguing implied reservation, right? Andy will be arguing implied reservation. Reservation is necessity or common intention. Is it a necessity for him to drive his car across the garage forecourt? Clearly not. It's not even a matter of debate. No, the examiner has made it very easy for you. Why? Because the examiner said that's the way he drives. So now he cannot drive, but there is a small footpath for him to get to the house. So it's not that he cannot get to the house. It's just that he cannot get to the house by driving. And as we know, you want to add the case, huh? This is the case of re-MRA engineering, isn't it? The facts are very similar. So I know I didn't put it there, but you might just want to jot it down. Huh? Re-MRA engineering. Very similar facts. Huh? There also, the guy wanted to drive the car all the way to his house. He's asking for an easement. The court said, no, you can walk. You can walk. Right? So it's not necessity. Can it be common intention? I think it's difficult. Huh? There was no discussion between Andy and Barney that he will want to drive his car. And also, it's not that the house cannot be used as a house without that easement. It's not that, right? So it's not going to be common intention. It's not going to be reservation, and so Andy will not be allowed the easement, right? Common intention by way of reservation. Remember, guys, Chaff against Kingsley. The courts are not going to lightly grant implied reservation, especially for common intention. They are really not going to lightly grant. Chaff against Kingsley expressly says this. Right? You have the spelling of Chaff against Kingsley in your notes. Okay. How's it going? Let's look at another one. The 2017 question. Wait, Okay, take a few minutes, read this one. This question, when I read it also, I thought it was a strange question. Huh? See whether you share my opinion or not. I can't put it all in one screen, so I will move it up. Those of you that are reading the main screen, I will move it up in a bit. Okay. You read with me once. Tariq owns the freehold title to a detached house, Greenacre, in a rural part of Devon. I'll be honest with you. I spent a good portion of my life wondering what is the value of this part of the question, in a rural part of Devon, England. As it turns out, it's got no value to this question. So as much as I say every word the examiner matters or whatever, sometimes he's just putting it there. It's got no value. The law applies the same in a rural part of Devon or the urban part of London. There's no difference in the law depending on where it is. So honestly, I did. I sat down and I thought about why the examiner said in a rural part of Devon, and I haven't found an answer. If you think of anything, let me know. Right? Greenacre is registered land. Okay. The house is surrounded by 1 acre of gardens and grassland. Tariq bought Greenacre from Dominic in 2010. Greenacre had formerly been a part of the land known as Brook Farm, right? Okay, so let's try and draw this out. See whether my drawing is similar to what you pictured in your mind. So he owns the freehold title to a detached house. Okay. This is Greenacre in a rural part. Okay. The house is surrounded by 1 acre of gardens and grassland. So surrounded by 1 acre of gardens and grassland. Greenacre in totality was formerly been part of the land known as Brook Farm. So is Greenacre the house or Greenacre the whole piece of land? House, definitely, right? Tariq owns the freehold title to a detached house, Greenacre. So only the house is Greenacre. It is surrounded by 1 acre of garden and grassland. Greenacre had formerly been a part of the land known as Brook Farm. Okay. Dominic owns the freehold title to the farm, Brook Farm, which borders Greenacre. So we call this Brook Farm. So last time Greenacre was part of Brook Farm, now it is not, okay? So the surrounding part, maybe this bit here is... okay. Then Dominic owns the freehold title to the farm, Brook Farm, which borders Greenacre. Dominic inherited Brook Farm from his father. Brook Farm is registered land. Okay. Dominic keeps cattle on his land. Okay. Once a week since 2010, Dominic has led his cows from Brook Farm across grassland at the edge of Greenacre to another field, which he also owns on the far side of the main road. So from Brook Farm, Dominic takes his cows on the edge of Greenacre, right? So it is on Greenacre, the edge of Greenacre to a separate farm, okay? To another field which he also owns on the far side of the main road. Dominic claims that 30 years previously, his father used to walk his cattle along an identified path across the land that is now Greenacre. So last time, when the whole thing was Brook Farm, Dominic is claiming that his father used to walk the cows when the whole thing was Brook Farm. Okay? He is unable to prove this. Interesting. Dominic also claims that it is essential to be able to walk my cattle to the other field because my main field cannot sustain grazing for my cattle all year long. So this is like a little bit of invitation for you to discuss necessity here. But it doesn't say that that is the only way to remove, to take the cows, the cattle to graze somewhere else, isn't it? It just says, what Dominic is saying is, it is essential that he takes his cattle to another field, because Brookfield alone cannot survive. I mean, it's not enough. But it is not essential that he goes that way. He could go another way, isn't it? Tariq claims the entirety of Greenacre is needed for his future business plans, and therefore he cannot have cows walking across it. He intends to construct small buildings for tourists to occupy for holidays. So the first thing here is Dominic is going to claim for the right of way to walk the cattle across Tariq's farm, Greenacre, right? Tariq also wants to attach a large sign advertising the tourist accommodation on the wall of a barn on Brook Farm. Okay, so on Brook Farm, somewhere on Brook Farm, there is a barn, right? There had previously been a sign attached to that barn before Tariq had acquired Greenacre. The sign had advertised the farm shop, which had formerly been operated by Dominic's father on Brook Farm. Okay. This is why I said this question is a bit weird. Huh? Isn't there a lot of ambiguity in this question? Right? And that's a sign of a bad... I mean, I know I keep saying ambiguity and all that. Here, it's a little bit difficult to even understand the question, in my opinion. You see here, look at this paragraph. Huh? So Tariq wants to attach a large sign advertising the tourist accommodation. So there is a barn on Brook Farm, right? So there is a barn on Brook Farm. Okay, fine. There had previously been a sign attached to that barn before Tariq acquired Greenacre. The sign advertised the farm shop, which had formerly been operated by Dominic's father on Brook Farm. So where is the farm shop? We don't know, isn't it? You know why? Because last time the whole thing was called Brook Farm. Not just this was called Brook Farm, right? Greenacre and Brook Farm was collectively known as Brook Farm. I mean, that's what I understand from the question, right? So when you say that the sign had advertised the farm shop, which was formerly being operated by Dominic's father on Brook Farm, is the farm shop here? Or is the farm shop here? Now you are asking me what's the difference? A big difference. I'll tell you why. If the farm shop was here on Greenacre, and then both was owned and occupied by the same person, and then a business here was being advertised on the barn wall, this is quasi-easement, sell the dominant tenement, all quasi-easements will become full easements in favor of the buyer. This is Wilden against Barus. But if the farm shop is here, then it's not Wilden against Barus. So read again. There had previously been a sign attached to that barn before Tariq had acquired Greenacre. The sign had advertised the farm shop, which had formerly been operated by Dominic's father on Brook Farm. The sign was still attached to the barn when Tariq went into occupation of Greenacre. Dominic took that sign down 6 months ago. So there is a little bit of ambiguity, but if I remember correctly in the question, we will address it. You'll see later, we will address it. Tariq has planted a thick line of prickly holly bushes across the path that Dominic uses to move his cattle to the alternative field, and has placed a padlock on the gate leading across Greenacre from Brook Farm, which means Tariq is now stopping Dominic from bringing his cows. If Dominic has an easement, you argue that Dominic has an easement, Tariq cannot do that. That's the whole issue here. Advise Tariq and Dominic as to their rights. Right? So, ladies and gentlemen, in my opinion, this is a strange question. Huh? Number one, there are only two rights, which immediately you might think, oh, that's good, less things to write. But it also means my answer is very short. So this is one of those questions that even though I finished the answer, in my many years of experience, I'm confident there's nothing else to write. But at the back of my mind, there's always like, and I've also taken a look at the examiner's report. It doesn't say anything different as well. You all have access to examiner's reports, right? At least the last 5 years. All this is in your student portal. Please read examiner's report. It's a very, very useful tool. It's a very, very useful resource. It tells you what the examiner doesn't like to see, and then don't do it, right? Read the examiner's reports. Okay, so let's see how I would have answered this question. I tell you what, no, we're not going to do that. We're going to stop here now. Earlier, I told you, I'm going to call the helper in now. She's going to give you those forms that she wants you to fill up. Just fill that up. I will give you like 10 minutes to do that. And then after that, you get a 10-minute break. Okay. Then we come back and we continue with this. Okay. Yeah. Okay, let's start. So my answer outline very quickly is similar, right? So it's the right of way for the cows. Dominic is claiming for that. The advertisement sign, Tariq is claiming for that, right? So are there any issues with regard to the re-Ellenborough requirements, right? When it comes to the both the rights, are there any issues with re-Ellenborough? Again, guys, as we are having done more and more questions, I'm going to move a bit faster because you know what is the dominant tenement and what is the servient tenement and all that. We don't need to get into that again, right? So let's get straight to, does it accommodate the dominant tenement? So advertisement signage, I think every time you see advertisement sign, I think it's a good possibility that it will be the issue of economic benefit, right? Pure commercial benefit coming out of the easement, which means that it benefits the owner, not the land, right? So advertisement signage is going to be very similar to the answer earlier, right? Whenever you see advertisement, I want you to highlight that you know that Moody and Steggles is advertisement. And in Moody and Steggles, it was allowed. But maybe the circumstances here are very different, right? So even though it is an economic benefit, you apply the case of London and Blenheim Estates and apply it, discuss it, and you will come to the conclusion that it doesn't matter whether or not it is an economic benefit, right? It doesn't matter whether it's an economic benefit, it will still it possibly can be an easement as long as the benefit is obtained because the dominant tenement owner owns the estate in the land. So ask yourself, Tariq, what does he want to advertise? He wants to advertise his the business that he wants to start, right? He wants to advertise the tourist. What is he saying? The tourist accommodation, that's right? He wants to advertise his tourist accommodation. So Tariq wouldn't benefit from the advertising signage if he wasn't the owner of the dominant tenement, isn't it? If he wasn't the owner of Greenacre, if that was not the place where he was doing his business, having an advertising signage in Brownlands won't make sense, right? So that is why you will argue that, yes, it may be that Tariq is getting an economic benefit, but it's okay. He is getting that economic benefit because he owns the estate in the dominant tenement, right? What about the right of way? Does that benefit the land? Definitely so, isn't it? The right of way benefits Brook Farm because it serves as a connection to the other land that is owned by Dominic, right? So any owner of the land that comes on also will benefit from that right of way, right? Will benefit from the right of way so that the cattle can go to feed in the other land. Now, again, same thing. If you in the exam question felt that even the cattle is going to be economic benefit, because it doesn't seem like he has one cow, right? It seems like he's got many cows and sheep and all that, and usually people keep many cows and sheep. I mean, not for personal consumption, isn't it? You keep it as a business, right? Then if you think that that pathway is economic benefit, then you just have the London and Blenheim test discussion. Okay? Then, the alleged easement must be capable of forming the subject matter of the grant. No issues here. Huh? Capable grantor, capable grantee. None of them. See, okay, so you might be asking, so in what circumstance would they not be a capable grantor or a capable grantee? So for example, let's say if Tariq didn't own or lease Greenacre, then he's not a capable grantor or a capable grantee. Or he is only on the land by virtue of being a licensee. See, these are circumstances. So these are circumstances that you should watch out for. But on our facts, no problems. Are these rights capable of being easements? Definitely, right? Advertising signage, Moody against Steggles. The right of way across the land, Borman against Griffith. So these are rights that have been recognized as easements prior to this. So we shouldn't have a problem. You know, every question I tell you, there's a degree of use issue, isn't it? Here, really, I don't think there's a degree of use issue here, because one of the easements is a right of way. There can never be a degree of use issue in a right of way. Because what is a right of way? It's a path to walk, isn't it? So even if you bring 100 cows to walk, Tariq also can walk. Remember, the whole degree of use is you are using that right to the point where Tariq no longer has reasonable use of his land. With the right of way, there can never be a degree of use issue. Right? So there seems to be no degree of use issue. Even with the advertising signage, also no issue. Right? So this is why I thought this question was a strange question. Anyway, no other factors that negate an easement. What are the other factors? Can we do a quick revision? So the degree of use was 1. Do you remember what are the other factors that could possibly negate the easement? Expenditure of money by the servient tenement. If the servient tenement owner has to spend money to upkeep that easement, then that cannot be an easement. Right? That's another one, right? And usually also, there can be no negative easements. Remember that as well. No negative easements. Meaning, I cannot claim for an easement on your land that you cannot build on your land. I cannot claim for an easement that you can only use your land for business purposes. So those are not easements. So those are negative rights. Negative rights cannot be an easement. An easement is I going to your land and doing something on your land. It cannot be I want you to not do something on your land. That's not an easement. But the good news is there's something else for that, isn't it? That's what we call a covenant, right? A freehold covenant. You can have positive covenants and restrictive covenants there. Right? So none of these other factors apply. So we'll say that both rights are capable of being easements. Both rights are capable of being easements. So then what about acquisition? So let's start with the advertisement first. Right? Assuming that there was no express grant of the right. So again, I always say that, right? Assuming that it was not expressly granted, we have to look at the possibility of it being implied. Okay, Tariq will argue an implied grant. Would that be correct? I think so, right? Remember, Tariq is he has just bought the land and he wants a right on his neighbor's land. So it's going to be a grant situation, right? Its reservation would be if Tariq was the one that owned both land, and then he has just sold one land and is claiming for a right on that land, right? That is reservation. So this is not. So this is going to be a grant situation, right? So this is not necessity, not common intention. Now, the common intention discussion would have been possible. It would have been possible. But you see, the thing is, Tariq claims that the entirety of Greenacre is needed for his future business plans. So remember, common intention must be where the seller of the land knew why you were buying the land. Right? The seller of the land, when Tariq bought the land from Dominic, let's say, Dominic must have known that Tariq was buying this land to have this tourist accommodation. Then possibly you can have a common intention discussion. For example, like Wong against Beaumont. Remember the restaurant case? The restaurant in the basement case. Wong against Beaumont. Yeah, and so similar cases like that. So I am arguing it won't be by way of common intention because the plans for the tourist accommodation possibly is future plans, something that Dominic could not have known at the time of sale. Now, if there's something in the facts that indicate otherwise, then of course you must You must say so, lah, right? But on our facts, it doesn't seem like that. Okay. Now, if it's not going to be necessity, is not going to be common intention, then let's try the rule in Wealden against Burrows, right? The rule in Wealden against Burrows. Okay. Explain the rule. By now, I think all of you are comfortable with the rule already, right? Once again, right? The more I repeat it, maybe the more it'll stick. Huh? What is the rule in Wealden against Burrows? When the landowner sells the dominant land, sell or lease the dominant land, all quasi-easements that were enjoyed by the seller, that were used by the seller, will become easements in favor of the buyer. Right? So, were there any quasi-easements prior to that or not? We are told that Dominic's father was using the advertisement to advertise the farm shop that was previously on Brook Farm. Right? Greenacre was previously part of Brook Farm. So this is what was not clear. Remember earlier I told you, this is the unclear thing. So, I mean, again, we have to accept ambiguity in the question, right? It makes your life a little bit more difficult, but we have to accept and we have to roll with the punches. So this is what I have argued, right? Greenacre was previously part of Brook Farm. So if the farm shop was on the land on Brook Farm that today is Greenacre, then that would be a quasi-easement. Do you understand why? Right? Have I rubbed off the... Yeah, I have. Right? Remember, huh? This is what we are saying, right? So this is Greenacre, and this is Brook Farm, and this is the barn, and the advertising signage is on the barn, let's say, right? Now, last time, Dominic's father, Dominic owns Brook Farm and Tariq owns Greenacre now, right? But prior to this, Dominic's father used to also use this advertisement, but he used to advertise his farm shop. The issue is, where was the farm shop? We are told in the question, the farm shop was on Brook Land, right? Was it Brooklyn or Brookfields? Anyway, Brookla, right? It was on, but last time Greenacre was also known as Brookland. So the thing is, if the farm shop used to be here, then, ladies and gentlemen, what we have now is the dominant land, a quasi-easement that was enjoyed by the dominant land, and when Dominic's father sold the land to Tariq, it will convert into an easement in favor of Tariq. But if the farm shop was here, and we genuinely don't know, then this whole Wealden and Burrows argument doesn't apply. Okay? I need everyone to see why this is going this way. I told you it's a strange question, a little bit strange. But, you know, sometimes questions like this come out, right? So, coming back to this. Greenacre was previously part of Brook Farm. If the farm shop was on the land on Brook Farm that today forms Greenacre, then there is a possibility that Wealden will apply. But if the farm shop was not on the land that today forms Greenacre, then Wealden will not apply. Okay? So, then, if the farm shop, so if we go back to the first possibility, if the farm shop was on the land which is now known as Greenacre, then Dominic's dad was using the advertisement. This would have been a quasi-easement. Why? Because Dominic's dad owned this land, Brookfields, and then owns this land, Greenacre, and then the farm shop was here, and he was advertising it in the barn. This is your classic quasi-easement. And then the dominant land is sold, and the new owner will get it by virtue of the rule in Wealden against Burrows. Right? There are some conditions. What are the conditions? 2, the right must be continuous and apparent and necessary for the reasonable enjoyment of the land. Is it continuous and apparent? I think it is, right? It has been there all the way until the time that Tariq bought the land, right? Let's see. There had previously been a sign attached to that barn before Tariq had acquired Greenacre, right? The sign was still attached to the barn when Tariq went into occupation of Greenacre. So that solves that's a problem, right? That means up until Tariq bought the land, the advertisement was still being there and being used. So, ladies and gentlemen, it is continuous. Is it apparent? Apparent. Like I said, advertisements that are not apparent are terrible advertisements, right? So I argue that it is apparent. It's clear. Everybody can see. Continuous and apparent and necessary for the reasonable enjoyment of the land. This is not the same as necessity. So would it be nice if you were running a business to have an advertisement? Yeah, it's necessary for the reasonable enjoyment of the land, right? So we are good. Discuss, right? So which means you discuss it in full, right? Both are satisfied. Tariq will get the easement by way of implied grant using the rule in Wheeldon against Burrows. Okay, interestingly, if the facts are same, can 62 apply for Tariq or not? If the facts are similar, so the facts are similar means the farmhouse was here, right? Let's say that. Can 62 apply for Tariq? So let's try, right? For 62 to apply, 62 in its, well, no, prior to the sale, it was not licensed, there was no license, there was no second sale. Yeah, no, 62 won't apply as well, right? Can 62 apply? The answer here is no. Even if you use plat and crouch as well, no. Okay, then moving on. The right of way for the cows. Dominic is claiming for this on the land that he previously owned. Correct? Or at least his father, right? But he is claiming for the right that he previously owned. If it was not expressly granted to him, he will have to argue reservation. So Dominic owns Brookfields and used to own Greenacre. It has been sold to Tariq. Now Dominic wants the right to continue using Greenacre. That is reservation. Is it going to be necessity? Cannot be necessity. Doesn't look like it's common intention as well. Anyone disagree with me? Right? It doesn't seem like it is common intention as well. Remember, what is common intention? Right? If we go back to the notes, you take a look at it. Common intention means either there was an agreement or there was an agreement as to how the land was going to be used. That means both parties knew what the land was going to be used for. And this easement is necessary or is needed for the land to be used in that way. Okay? Okay, good. So now, ladies and gentlemen, let's look at more questions. Okay, so right now I don't have answers to these questions. So we're going to take it down. Let's try, right? You jot down some bits and pieces here, right? So I've got two questions here. This was not forwarded to you, so don't look in your email. This was not sent to you, right? Yesterday I realized that we may have more than enough time. So once we go through these two questions, then I really have nothing else to do with you. So we will finish, right? After we finish these two questions. But let's try. Let's try this question. This is a 2015 question. 2015 question, question 6, zone B. Try and read the question, please. These pictures, I want you to know, I'm genuinely reading it and drawing it on the spot. You might think that I practice at home and all that. Not really, right? So let's see whether your understanding of the question is the same as mine, right? If I didn't tell you, if this was not an Eastman session, and I told you this is an Eastman question, would you have figured out this was an Eastman question or not? So, ladies and gentlemen, as part of your study process, please allocate some time to look at past year questions, not from the notes that I give you or your lecturers give you. Download full exam papers from the portal and just look through. Can you deduce, is this a registration question? Is this a co-ownership question? If it is, right? Because again, guys, if you haven't been doing that, your only exposure to exam questions is me telling you this is an Eastman question. I'm not going to be lying to you, right? So you have that faith, but you need to be able to identify questions. That is why I always emphasize a lot on, I want you to read the question first and pick out issues. You need to see what is the pattern in an Eastman question and what is the pattern in a co-ownership question, in a proprietary estoppel question, so that you can identify it. Sometimes the examiner will be kind and he will say, discuss the adverse possession issues that arise. But most of the time they won't. Remember, there was 1 year, I don't know whether I did it with you or not. It's a property law question, right? The examiner says, discuss the private law issues that arise. So everybody's like, private law? Daniel didn't teach us private law. He skipped a chapter, useless fella. But the point is, private law, what does private law mean? Anything that is not public law is private law, right? Land law is private law. Contract law is private law. Family law is private law. Whenever law is between two individuals or an individual and a company, that's private law. So the examiner is such an unnecessary move. But he said, discuss the private law issues that arise. And students got stuck. Some, not all, but some. They were like, they got nervous. What is this private law? I've never heard of that before. So sometimes you can get examiners whose main intention there is they design the question with a little bit of cheekiness, to trick you. Maybe it's a small joy that they have in their lives, right? Don't let small things like that get to you. You understand that? So I'm being serious. So I know all of you are studying every night with your textbooks open and highlighting and doing notes and all of that. But apart from that, you also need to allocate some time, I think, to take a look at the raw exam question. Just download the papers and see whether you can spot whether those are questions or not. Then, of course, as you're doing that, try and do one or two. Just practice. It will be useful. Okay, let's read this. Let's try. Charlie was registered owner of Harrow Farm. So the whole thing is Harrow Farm, right? And Harrow Farm consisted of a farmhouse set in a large field, right? Harrow Farm consisted of a farmhouse set in a large field and a small cottage. I figured this wall garden should have been smaller, I think, now that I read this question. But anyway, a small cottage, Rose Mews, which sit in a walled garden alongside the farmhouse. So for me, this is Rose Mews. It was supposed to be smaller. And I suppose the wall garden is this. Okay. The front door of the cottage could be accessed via a drive across the large field. So all of this rest of the land is the large field, as far as I'm concerned, right? So there was a drive across the large field. So maybe perhaps the drive was also something like that, right? So there was a drive across the large field that you can access the cottage, right? But there was an alternative means of access via a narrow path. So this for me is the narrow path. The narrow path that ran from the back door of the cottage to the main road. Okay, so I didn't draw the main road, so I would picture the main road to be somewhere here, right? In 2008, Charlie granted a 5-year lease of Rose Cottage and the wall garden to Deepak, a sculptor. So 2008 is the first lease. Okay. A few months after the lease was granted, Charlie told Deepak that he could use a shed at the corner of the large field to store the stones he used for his sculptures. When the lease came to an end in 2013, it was renewed for a further 5-year term. This seems to be very typical. Huh? Lease, license, lease again. Right? When you see that, you know that chances are, I mean, it's still preliminary, but chances are there should have been a bell ringing in your head, huh? That for the shed, it's going to be 62. It's going to be 62, right? Okay. Charlie has now sold Harrow Farm to Eric, who wants to build an extension to the farmhouse on the field. This will result in the shed being demolished, the drive being blocked, and the drains to Rose Mews, which currently run under the field, being removed to make way for the extension's foundation. Okay, so the new guy, Eric, what does he want to do? He wants the shed to be demolished. So obviously, Deepak wants to continue using the shed. And then the drive being blocked. So this drive will be blocked. So Deepak obviously wants to continue using the drive, isn't it, right? Deepak wants to continue using the drive. And the drains to Rose Mews. Rose Mews is the small cottage. The drains to Rose Mews, which currently run under the field. So this is the field. Right? The whole thing is under the field, right? Currently run under the field, being removed to make way for the extension's foundation. So, how many rights here are we talking about? So the structure of this question is a little bit different, right, from the one that we've seen. I think the one that we've seen prior to this was a lot more straightforward in telling you that these are the 3 rights. Here, I found that it wasn't that straightforward. You only found out the 3 rights that are in issue in literally the last part of the question. Here, because until this last line, there was no talk about drains at all. Imagine if you were reading the question really fast and then you skipped it, or accidentally you missed it, you wouldn't have talked about drains at all. Well, you shouldn't know. Okay, so I think there are 3 rights that are being claimed, right? The shed, the drive, and the underground drains. Right? The underground drains under the field. Okay, who was claiming for all of them? All of them are being claimed by Deepak, correct? Is there any indication that perhaps Charlie is claiming for them? No, you know why? Charlie's gone, right? Is there any indication that maybe now Eric is claiming for them? Not really, because Eric is coming in and seems to be destroying everything, right? So Deepak is claiming for all 3 rights. Okay, very good. So that means there's no reservation. Huh? If Deepak is the one that is claiming, it cannot be reservation. Did you all figure that out? So there's no issue of reservation in this question. All 3 have to be a grant situation. Okay, now, re Ellenborough Park, requirements. Is anything going to be an issue for these three? The shed, the drive, and the drains to Rose Mews. Well, does it benefit the dominant tenement? So which is the dominant tenement here? Rose Mews and the walled up garden. Would you agree? Right? The dominant tenement is Rose Mews and the walled up garden. And the servient tenement is the rest of the farm, Harrow Farm. Everywhere else is the servient tenement. The big farm, the farmhouse, the garden, not garden, what is the field? The big field and all that is the servient land. Okay? Fine. Is there diversity of ownership and occupation? Yeah, quite clear. There is. No issue, right? Can we say that it accommodates the dominant tenement or not? Do these rights accommodate the dominant tenement? Are there any right here that you think will be commercial benefit? Well, I mean, if you put a gun to my head, what's his job? Sculptor. What is he putting in the shed? Is it his sculptures or the stones? To store the stones that he used for his sculptures, right? So you could argue that is related to his business, that is related to his job. Potentially that is a commercial benefit argument there. But other than that, the drive, that's definitely not a commercial benefit. It's just the way that he will use to drive to his house, right? So I don't think that's a problem. But does it benefit the dominant tenement, the drive? Surely it does, right? Right? Having a drive obviously means that it's a path that you can drive on, right? So having the drive straight to the house, Rose Mews, is always going to be an advantage. Because alternatively, what do you have? You have a narrow path. So path is usually for walking. So again, I honestly think that this is a little bit unfair, but you know, they should have clarified path. But if the normal English usage of the word path means it's a place that you don't drive. So drive obviously is where you drive, right? So if the drive definitely benefits Rose Mews. Why? Because if not means the owner of Rose Mews will have a way for them to drive their cars all the way to Rose Mews. So it benefits. And underground drains, surely underground drains benefit, right? If not means when you flush your toilets, it doesn't go anywhere. That's going to be a problem, right? So underground drains are benefiting the land, definitely. And it's not a commercial issue. So I would argue the storage in the shed, use London and Blenheim estates, that same story and all of that. The other two directly benefit the land. That's how I would argue it. Okay? Anyone disagree? Okay, then, next one. The fourth requirement in Re-Ellenborough Park. Are these rights capable of being easements or not? So again, capable grantor, capable grantee, all will be satisfied. What are the cases to show that these are recognized easements? The drive, what is that? An easement of a right of way. What case would you argue? What case would you put? Bowman against Griffith, right? The shed is the easement of storage. When it comes to storage, what would you use? To be fair, storage, I think we've never seen in all the questions we've done. So if it's storage, I would suggest, again, there are hundreds of cases, but the case that comes to my mind is always right against Macadam. Right against Macadam. The spelling and all is in your notes, right? That is for storage. And underground piping or underground drainage. This is another case that you have. We've not seen it so far. Donovan versus Rana. Donovan against Rana. Well, so if you have all these cases, you've covered the 5 that I've told you. What are the 5 again? To have advertising signage, parking, storage, right of way, underground piping, underground drainage. These seem to be the regular ones that come up. Have 1 case each for all of them. Again, just to show that it has been recognized as an easement previously. Okay. Now, are there any potential issues here? Definitely. When you see shed, you know you're going to talk about degree of use. When you see an enclosed space like shed, barn, storeroom, whatever else like that, you know it's going to be degree of use. So discuss that. Right? We don't know how big the shed is. We don't know how big Deepak's stones are, isn't it? Right? So if he's put so many stones, or the stones are individually so large to the point that Charlie or now Eric no longer have reasonable use of the shed, it cannot be an easement. Are we good? So again, the structure of the question is a little bit different, but they cannot run away. They're going to ask you the same things, right? They keep asking you the same things again and again and again. Okay, any other re-Ellenborough issues you think we have missed? I think we've covered it all, right? Okay, then let's move on to acquisition. So acquisition, let's do it one by one. Shall we start with the shed? There's no rules, huh? You can pick whichever you want. I'm going to start with the shed. What are we going to do with the shed? What method of acquiring? By the way, do you think there's a chance of this being expressly granted? Definitely not. Tell the examiner. It doesn't seem like it's expressly granted, so Deepak has to claim for an implied easement, right? Deepak has to claim for implied easement. This is all implied by way of grant. Everybody agrees? This is not reservation. This is grant. Okay. Which method? The shed. Necessity? No. Common intention? No. But remember the shed, I told you already, from the beginning, when you read the question already, you would have circled it and you would have drawn a line and you would have said 62. Why? What was the big giveaway? Lease, license, and then after that, another lease or sale. But in our question, it's another lease. When you see that, you know that they are testing you on 62 read together with Hare versus Gilman and Inskip, which simply means what? That license, if 62 applies, that license will be converted into a full easement in favor of Deepak. So, can 62 apply? 2 conditions. Condition number 1, the lease must have been a conveyance. Which lease are we talking about? 2008 or 2013? 13, isn't it? Right? Okay. Right? You're right. You're right. It's 2013. Right? It should be obvious, huh? But look, it's like literally your 3rd day of studying easements. So I don't presume, right? But by the time you reach the exam, it should have been like, of course it's 2013. Why are you asking me a stupid question? That kind of a thing, it should be there, you know what I mean, right? So it is 2013. So the 2013 lease has to be done according to the proper formalities, which for a lease means deed. There's no deed plus registration, right? Unless it's a estate, then it's deed plus registration. So you don't have to get into all of that. Just say, as long as it was done using the proper formalities, it will be a conveyance. We don't know, we assume. Secondly, prior diversity of occupation at least. Case, Those funny sounding cases, huh? Long against Gowlett. Sovmot against the Secretary of State for the Environment. All these cases are in your notes, right? They say there must be prior diversity. Do we have prior diversity? Prior to what? The 2013 lease. Nah? Prior to that, do we have it? Yes, we do. So 62 will apply. 62 read together with Hare versus Gilman and Inskip will say that that license to store the stones in the shed will now be an easement for Deepak. So Deepak is advised that Eric will not be able to demolish the shed. Not too bad, right? Let's move. Next one. Shall we do the drive? Okay, let's go in the order in which that it has been here. So shed first, then the drive being blocked. The drive being blocked. Okay, interesting. What do you think about the drive? I think the drive and the drains might be a similar discussion. I'm thinking Wealden against Burrows. Why? Do you think that before the land was sold to Deepak, so land meaning Rose Mews and the wall garden, surely Charlie was driving on the drive to go to the cottage. Would you agree? Okay. If you're saying, how you know, Daniel, you're inventing facts. Okay, fair. I will agree with you. But for the second one, the drainage, that one, surely he was using it, right? I mean, even if he wasn't staying in the cottage, the drains to that, he must have been using it, right? The water, wherever in that house, whatever wastewater would be going under the drains, right? So for me, the underground drainage is going to be Wealden against Burrows for sure. Quasi Eastman was when Charlie was who owned everything, including Rose Mews, surely would have been using the underground drainage. So that's going to be Wealden for me. Easy. I think it satisfies all the requirements, continuous and apparent. Remember, even though it's underground piping, it is apparent, right? You can argue that. And then necessary for the reasonable enjoyment of the land. So fine. What about the drive? Can we do necessity for the drive? Definitely not, isn't it? Right? So cannot. Do you think common intention? So nowhere are we told that Charlie and Deepak were under the impression that Deepak will drive to Rose Mews. There's nothing to indicate that, right? Right? He knows he's going to stay in Rose Mews. He knows he's going to do his sculpture, but there was no indication that he must drive to Rose Mews. So I don't think it's going to be common intention also. So you can argue, and I would argue, if Charlie also used that drive regularly, if Charlie also used that drive regularly, then Deepak will get it by way of Wealden against Burrows. But if Charlie didn't, then he's not going to get that easement. Right? I'm arguing that the underground drainage, that is definitely going to be used regularly. I think even if a house is not used, the drainage is still used, right? Even if no one goes and flushes the toilets and all that, the drainage is important, necessary for the continued existence of the house, right? Does everybody make sense? I mean, does it make sense, my discussion? Does anyone disagree with me? So, conclusion, the shed definitely is going to be there. The drainage, I am arguing, is going to be there for Deepak. The drive depends. Depends on whether Charlie was using it prior to the sale or not. Last question. Let's take a few minutes, read this. Well, let's just read it together, right? Adele owned Green Gates, title to which is registered. Green Gates comprised a furniture shop and an adjoining house. Oh, this is going to be an interesting question. Green Gates comprised of a furniture shop and an adjoining house. Okay. In 2011, when Adele retired from running her business, she leased the furniture shop to Jesse, but retained ownership of the house. Okay, let's start there, right? So the usual two boxes. So it seems like this is the house, this is the shop. Adele owned both. But then what has happened? Adele leased the furniture shop to Jesse. Okay? But retained ownership of the house. Okay. Earlier this year, when the lease came to an end, Jesse purchased the registered title. Okay. So after the lease, it was sale. So obviously we have a lease and then we have a sale after that. So earlier this year, so that is 2014. So originally there was a lease in 2011 and then there was a second lease as the sale happened in 2014. Okay. Jesse purchased the registered title of the furniture shop from Adele. Jesse now needs your advice about each one of the following matters. Okay. Is Adele entitled to replace the underground drains in the garden of her house? So this is the house. So there's a garden here, let's say. Jesse is concerned that Adele's proposed new drainage system will no longer serve Jesse's shop. Let's talk about that. Which method? Okay, so again, let's forget re Ellenborough Park for a while. Let's forget about that for a while because that's easy. You all are experts in that already. The which method of acquisition? This one. What do you think? What are your thoughts? The thing. So your thought process should be Adele was both owner of both pieces of land. When she was owning the shop, surely she would have been using the underground piping as well, isn't it? The underground drains. So now, when she is no longer owning the shop, she has sold the shop, she wants to divert the drains in a different direction, which will mean that the shop will not have, the drains under the shop will not be connected anymore. So our Jesse wants to stop that, correct? So Jesse will have to argue that the drains are an easement for her. How will she do that? She will do that by way of Wilden. Is everybody thinking Wilden? When Adele was owning the shop and the house, and when she was using the drains under the shop, that would have been what? Quasi-easement. Now sold the dominant land. Which is the dominant land for the piping, the drain? Which is the dominant land? The shop, isn't it? Sold the dominant land. All quasi-easements will be converted into full easements in favor of the purchaser of the dominant land. Did you see it? Okay, so that's going to be a Wheeldon and Burroughs discussion. Let's just pick up the highlights first, right? Next. Can Adele insist upon replacing the broken TV satellite dish that is hanging on the side wall of Jesse's furniture shop? Adele insists that the shop wall is the only location from where it is possible to receive a reliable TV signal for her house. Jesse, however, wants Adele's unsightly satellite dish permanently removed without being replaced. What are initial thoughts? What's the first thing that popped into your head? Yeah, I'm hearing the whispers, which is good. So far, the whispers that I'm hearing are correct. But I hope all of you are whispering the same thing. Reservation, right? Reservation. Why reservation? Again, the person that used to own both has sold off or leased off one, and now wants a right on the land that they have just sold or leased. That's classic reservation, isn't it? So reservation. So it's going to be necessity or intended easement. Is watching TV a necessity? My mother will argue otherwise. Huh? Okay, next. Can Jessie continue to park her delivery van in the garage belonging to Adele's house? So there is a garage. Let's say the garage is here, right? Can Jessie continue to park her delivery van in the garage belonging to Adele's house? Jessie began parking there several weeks after the lease. So what are we having again? For like the third or fourth time today, I'm telling you. Lease, license, and then in this case, sale. Right? When you see that, you are looking at possibly 62, isn't it? But we shouldn't be that confident. Huh? We should read first. Jessie began parking there several weeks after she leased the shop from Adele in 2011. So after is a very important factor there. Huh? Adele suggested the idea because Jessie's van had been stolen from the road. Adele is now claiming that she needs the garage to park her new car. So Adele allowed Jessie to park, and then now there's been a sale, 62 will apply, right? If 62 applies, this will be what was previously a license. So this is obviously a license because it was an act of kindness on Adele's part towards Jessie, right? Because Jessie's van was stolen. Jessie was parking by the side of the road. Jessie's van was stolen. So Adele said, okay, don't park there anymore. Just come park here. This was an act of kindness. This was not official granting of a easement by any chance, right? So this was only a license. That license will be converted into a full easement in favor of Jessie. Okay? Now, so this is unique. How, if at all, would your advice to Jessie on A and B differ if Adele had sold the registered title to the shop to Jessie in 2011 rather than leased it? Only A and B, because C, it would be a total non-issue, right? So A and B. How would the answer differ if it wasn't a sale, but it was, if it wasn't a lease, but if it was sale? Honestly, the answer won't be different, right? Because whether it is a lease or sale, the impact is the same. You know where it would have had a difference? C. But they clearly are not asking you for C. Why C would have been a difference? Because if originally in 2011 there was a sale, and then after the sale, Adele gave a license, until today it will still be a license. There was no another transaction to convert it into a easement. Right? So interesting that the examiner has asked, would your advice differ for A and B, the ones that wouldn't change, and didn't ask you about C, the one that actually would have changed. Right? But yeah. So whenever Wealden and Burrows applies, or whenever any of these rules apply, it does not matter whether it's a lease or a sale, right? The rules apply in the same way. Okay, before we go home, re-Ellenborough requirements. Is anything here going to be an issue? The satellite TV dish is going to be interesting, because off the top of my head, I cannot think of a case that satellite TV dish is a recognized easement. But I would put it down as an easement of storage. I'm storing my satellite TV dish on your sidewall, right? So I would have gone with, if push came to shove in the exam, I'm stuck like that. It's still an easement of storage, isn't it? I want my satellite TV dish there, right? Other than that, anything else that you think potentially could be an issue? Underground drains, Donovan against Rana, parking, Newman against Jones. The parking in the garage is going to be a degree of use issue. Right? Surely you spotted that, right? Whenever you're parking the delivery van in the garage, the issue is going to be, we don't know how big the garage is. We don't know how big the van is. So if the parking of the van in the garage results in Adele not having reasonable use of the garage, it cannot be an easement. Benefiting the dominant tenement. Anything here is a economic benefit, you think? Well, it's the delivery van, right? What do you use a delivery van for? Your business. The right to park your delivery van. So arguably from that easement, Jesse is making money. The benefit from that easement to Jesse is money. If you wanted to go that way, you argue the Ladbroke case. Okay. So I hope I've proven to you. So in total, I think we've done 6 questions, right? 6 questions we've done, 2 without answers, but still 6 questions we've done. And I hope that I have illustrated to you that they can ask it in interesting different ways, but they keep asking the same thing again and again and again. Your job is just to calm down, relax, and push aside all the drama that the examiner is trying to introduce into the question, come back to the core principles of what there is, and answer it. Okay? Okay, guys, this is where I end today. I'm seeing you next, I think, March, early March. I think I'm doing the first revision, and then someone else is doing the second session with you all. I will be doing registration, co-ownership, proprietary estoppel, and adverse possession. And then the second session will be the other 4. If I'm not mistaken, right? I will go back and check, but yeah, we are dividing it that way, 4 and 4, right? If yeah, so if there are no further questions, ladies and gentlemen, I will be here. If you have any questions that you want to ask, not necessarily from easements, from any other chapters also, I'll be happy to answer your questions. But if you don't have any questions, then I will see you guys in early March. Thank you. You have one more session, but I can confirm that I'm not doing it. I think it's on adverse possession, if I'm not mistaken. Is that correct? No. Oh, that's done. Then what? Mortgages? Have you done mortgages? Okay. That means you haven't done mortgages, I think, right? Your next session will be on mortgages. All right, mortgages. Okay. I've mentioned before, I'll repeat it. I welcome questions, sample answers that you have done. You just do 1 or 2 practice questions. You want to send it to me, you can. You don't have to send it to Speed and Speed sends to me. You can just send it to me directly. All of you have my email address. You can just send it to me. Thank you.